My wife stood before a judge and told him I had contributed nothing to the life we built together. What she didn't tell him, what she couldn't tell him without unraveling everything, was that the company bearing her name, the one she described as hers alone, existed because I had made it possible. Every loan guarantee, every cash infusion during the lean years, every sleepless night I spent running numbers so her vision could survive contact with reality. She knew all of it. She had said so herself, publicly, with a microphone in her hand and 300 people watching. She just hoped I'd forgotten. I hadn't. Welcome back to Dad's Honest Revenge. Get comfortable. The people in these stories had every chance to do the right thing. They simply chose not to. Leave a comment below, and if you're new here, subscribe. You want to stay. The day my wife filed for divorce, I was sitting on the back porch in Henderson, Nevada, drinking decaf, because my doctor had told me real coffee was done, finishing the crossword I never finished, watching a roadrunner pick its way across the dry yard like it owned the place. I didn't hear the knock at first. When the process server finally got my attention, he handed me the envelope with the practiced neutrality of a man who had delivered bad news so many times it no longer registered as anything at all. I thanked him. He nodded and left. The roadrunner was gone. I set the envelope on the patio table, picked up my pen, and stared at 23 across for about 4 minutes before I accepted that I wasn't going to finish the crossword that morning. I want you to understand exactly who my wife thought she was divorcing. My name is Thomas Reeves. I'm 62 years old. I spent 30 years as a commercial lending officer and later a private financial consultant, which is a fancier way of saying I was the person businesses called when they needed money and didn't know how to ask for it correctly. I knew how to read a balance sheet the way other people read a novel, quickly, looking for the part where things go wrong. I had no patents, no published work, no business registered in my name. On paper, I was a supporting character in someone else's story. My wife Diane had the story. Diane Reeves Properties had grown from a 2-person operation in a shared office suite to one of the most recognized mid-sized property development firms in the greater Las Vegas Valley. 43 employees. A portfolio of mixed-use developments that had genuinely changed the look of 3 Henderson neighborhoods. 2 local business awards on the shelf in her corner office. A profile in Nevada Business Magazine that used the phrase self-made twice in the opening paragraph. The journalist who wrote it had never asked me a single question. Nobody ever did. Here's what that profile didn't mention. The company started in our guest bedroom in 2007. Diane had a talent for identifying undervalued land and a gift for convincing people that what she saw there was real. What she didn't have, in the fall of 2007, was access to capital. Banks weren't exactly generous that year, you may recall. And Diane's business plan, as thorough and color-coded as it was, could not clear a single underwriting desk she walked into. She came home one night in November and sat down across from me at the kitchen table and slid the plan across like she was making an offer and wasn't sure I'd take it. "Tell me what's wrong with it," she said. I read the whole thing 3 times. There was nothing wrong with it. The numbers were conservative, the projections were grounded, and the risk assessment was more honest than most plans I'd seen from people who had been doing this for 20 years. I told her so. "Then why won't anyone lend to me?" "Because it's 2007, I said, "and everyone is scared." She looked at me for a long moment. "Are you scared?" I thought about it. "No," I said. "I think you can do this." She exhaled like she'd been holding that breath for weeks. The first personal guarantee I signed on her behalf was for a construction line of credit totaling $420,000. I put my name under hers on a document that made me personally liable if the project failed, which meant our house, our savings, and 30 years of careful financial decisions were all sitting on Diane's instincts about a dry patch of land off Eastern Avenue. "I signed it on a Wednesday evening," she cried. "I made us both tea. We didn't talk about it much after that because that was how we worked. I put my name on the risk, and she went out and turned the risk into something real. For 16 years, that was the arrangement. I was the foundation. She was the building. The first project returned a net of $2.3 million in 18 months. The second one I personally guaranteed for $600,000. I personally guaranteed the third and fourth. When the company hit a brutal cash flow wall in 2013, a general contractor walked off a project to mid-completion and left Diane holding 11 months of unsettled invoices. I transferred $230,000 from my personal retirement accounts into the company's operating fund to keep the staff paid and the lights on while the lawyers sorted it out. I did not do this because I was a martyr. I did it because I believed in what she was building, and because I was her husband, and because that was the deal we had made without ever writing it down. I should have written it down. The court date was a Tuesday morning in late October. Judge Patricia Okafor presided, a composed woman in her mid-50s with close-cropped natural hair and the measured patience of someone who had long since stopped being surprised by the things people did to each other in the name of love. My attorney, Martin Cole, sat to my left. Martin was a slight, quiet man who wore suits that were always slightly too large for him and spoke in a voice that never quite seemed to reach the back of the room. He had never lost a case that mattered to him. He told me one thing before we walked in. Let them open the door. Then we'll show them what's on the other side. Diane's attorney was a man named Philip Hartwell. $60,000 suits, custom everything. The kind of professional presence that communicates competence before he said a single word. Diane had retained him 4 months before she filed. 4 months during which we had eaten dinner together most evenings, attended our granddaughter's first birthday, argued once about whether to refinish the deck, and behaved in every observable way like two people whose marriage was fine. Philip Hartwell stood and addressed the court like a man who had already won. Your Honor, this case is straightforward at its core. He never looked at me. Diane Reeves built a business. She built it through talent, vision, and extraordinary personal effort over 16 years. Thomas Reeves provided no specialized knowledge, no professional expertise, no intellectual contribution to that enterprise. He opened his folder. What he did do was maintain joint financial accounts and, on several occasions, transfer funds to the business. Transfers that under Nevada community property law constitute marital contributions for which Mrs. Reeves has already been credited in the asset valuation. He paused to let it land. The business is hers, Your Honor. The intellectual property is hers. The professional relationships are hers. Mr. Reeves is entitled to his share of liquid marital assets and nothing beyond that. He closed the folder and sat down. I looked at Diane. Diane was looking at the table in front of her. Martin Cole stood up slowly, unhurried, the way he did everything. Your Honor, the defense will demonstrate that Mr. Reeves did not simply transfer funds. He structured, personally guaranteed, and in multiple instances single-handedly sustained every phase of Diane Reeves' property's financial growth, from the original construction line of credit through the most recent land acquisition in 2022. He paused. We will further demonstrate that this was not passive financial support. It was the architecture on which the business was built, and we have documentation. Another pause, quieter. We also have something recorded. Philip Hartwell's pen slowed down. Martin sat down without further comment. I had asked him once what the something recorded was going to do to the case. He looked at me over his glasses and said, "It's going to end it." The first recess came at 11:15. I stood in the hallway outside Courtroom 7 with my jacket over my arm and my tie loosened, and my phone buzzed with a message from my daughter, Katie. Katie was 31, sharp as anyone I'd ever known, and had watched her mother and me quietly come apart for the better part of 4 years, with the specific sorrow of someone who loves both people and can't fix anything. "How are you holding up?" I typed back. "They said I never contributed anything. 3 dots. Then, Dad. Tell Martin to use the video." I smiled for the first time all morning. "He knows," I typed. "Good. Because Mom is about to find out what happens when you rewrite history with the person you rewrote it about, standing in the room." I put my phone away. My brother Frank appeared from somewhere. He'd driven in from Phoenix the night before, which was a 4-hour drive he had made without being asked, which was Frank entirely. He handed me half a granola bar, which was also very Frank, because he carried them in every pocket as if he expected famine at any moment. "I want you to know," he said, "that I am physically restraining myself. I can see that. That attorney described you like you were a coat rack with a checkbook. Frank. I'm restraining myself, Tom. I'm a model of restraint. I know you are." Martin appeared at my elbow with 2 cups of courthouse coffee, which tasted like it had been brewed during a previous administration. "They're rattled," he said quietly. "Hartwell didn't know about the recorded material." "How much did she tell him?" Martin considered this. "Enough to build a case that would have worked without what we have." He looked at me. "Not enough to survive what we have." He took a sip of the coffee and made a face he didn't bother to hide. After lunch, we opened the box. Thomas, he paused. When her expression changes, I need you to do one thing. Nothing, I said. He pointed at me. Nothing at all. The afternoon session began at 1:30. Martin Cole had a document box on the plaintiff's table, standard banker's box, brown and unremarkable, the kind you can buy anywhere. Philip Hartwell looked at it the way you look at something you're trying to decide is a problem. Diane was not looking at it. Diane was looking at it. Diane was looking at her hands. Mr. Cole, said Judge Okafor, you may proceed. Martin stood and buttoned his jacket once. Your Honor, I'd like to start with a timeline. He turned to face the courtroom. 16 years ago, Diane Reeves' properties did not exist. There was no company, no staff, no office, no portfolio. There was a woman with a genuine gift for real estate development, a color-coded business plan, and I saw Diane's jaw tighten, just barely, and a husband who believed in her enough to put his name, his retirement, and his personal credit on the line. He opened the box. The first document was a personal guarantee agreement dated November 14, 2007, signed by Thomas Allen Reeves as personal guarantor for a construction line of credit issued to Diane Reeves Properties, LLC. He carried it to the bench. $420,000, Martin said. This was the instrument that allowed the company to complete its first project. It was signed by Thomas Reeves, not by Diane Reeves Properties, LLC. By Thomas Reeves personally, which means that in the event of default, every personal asset he possessed was at risk. He let that sit. This is the document that made the company's first transaction possible. Philip Hartwell wrote something on his legal pad. Martin returned to the box. Exhibit 4, he said. A second personal guarantee, January 2009, for a $600,000 commercial construction loan. He placed it on the bench. Exhibit 5. A third guarantee, 2011, for $940,000. Exhibit 6. A fourth, 2014, for $1.2 million. He placed each one individually, deliberately the way you deal cards when you're certain of your hand. 4 separate personal guarantees spanning 7 years, totaling approximately $3.1 million in personal liability. $3.1 million against which Thomas Reeves's personal assets stood as collateral. He looked at Philip Hartwell. That's not moving money, counselor. That's carrying the weight. Philip Hartwell started to stand. Judge Okafor held up one hand without looking at him, and he sat back down. Exhibit 9, Martin continued, returning to the box. Bank transfer records 2013, $230,000 transferred from Thomas Reeves's personal IRA to the operating account of Diane Reeves Properties during a contractor default crisis. He placed the printouts in a neat stack. 3 senior employees on staff at that time, her current director of operations, her lead project manager, her head of accounting, all continued receiving paychecks that month because of these transfers. They don't know that, but the records do. He placed the last one down. Diane closed her eyes for a moment. Just a moment. Then she opened them and looked at the table again. Your Honor, said Philip Hartwell, rising, I'd like to object on the grounds of... On what grounds, counsel? Judge Okafor's voice was quiet and direct. Hartwell hesitated. The relevance of these historical transfers to the current valuation is directly relevant to the question of who built what. Mr. Hartwell, which appears to be the central argument your client made this morning. Judge Okafor looked at him steadily. Sit down. He sat. I did not smile. Martin reached into the box again, but this time what he removed was a sealed envelope. He broke the seal at the bench, which I knew was deliberate. Martin Cole did not do things by accident. Exhibit 12, he said. Email correspondence between Diane Reeves and Thomas Reeves, dated March through September 2021, during the company's negotiation of its largest single contract, a mixed-use development consulting agreement with the City of Henderson Community Development Authority, valued at $7.8 million. He placed copies before the judge and offered a set to Philip Hartwell. Hartwell received them the way you receive something you suspect is hot. I already knew what they said. I had lived them. March 4th, 2021. Diane to Thomas. The city wants a performance bond. $800,000. We don't have that liquid right now. I need you to back this one. I know I keep asking. This is the one, Tom. If we get this, we're untouchable. March 5th, 2021. Thomas to Diane. I'll call First Western in the morning. Send me the project specs. March 6th, 2021. Diane to Thomas. You have no idea what it means that you do this. You never make me feel like it's a burden. I've never once had to explain to you why this matters. You just see it. I don't know what I would do without that. Martin read the last email aloud, slowly and without drama, the way you read something when you want the words themselves to do the work. I don't know what I would do without that. He set the paper on the table. The courtroom was very quiet. I looked at Diane. She was looking at the wall behind the bench. Not at me, not at Martin, not at anything in particular. Just a fixed point somewhere above all of this. But we weren't done. Because Martin Cole reached into the box one more time, and this time, what he produced made Philip Hartwell set his pen down completely. Your Honor, Martin said, I'd like to draw your attention to Exhibit 15. He walked to a small projector, his legal aide, a focused young woman named Sandra, who had clearly been awake since before sunrise, had positioned quietly against the wall during the document presentations. The screen at the front of the courtroom came to life. This recording was captured on the evening of September 18, 2021, at the Henderson Chamber of Commerce Annual Business Excellence Awards dinner. Diane Reeves Properties was named the evening's Outstanding Development Firm of the Year. Martin looked at the screen. Mrs. Reeves delivered the acceptance speech herself. Philip Hartwell leaned toward Diane. She was very still. The video was 90 seconds long. The quality was clear. A professional chamber event recording, wide shot, podium microphone. 300 people in evening wear at round tables. Diane at the podium in a charcoal blazer, an award in her hands, looking out at the room with the specific expression of someone who has waited a long time for a moment and is trying to hold on to it. I had watched this video 11 times in the past 14 months. Not out of bitterness, out of something that was harder to name, because I needed to hear it, because I needed to know I hadn't imagined the whole thing. She began. 16 years ago, I had an idea and a folder full of spreadsheets and absolutely no way to make any of it happen. Quiet laughter in the room. The bank said no. The lenders said no. The market said it was the worst possible time. She paused. The only person who said yes was my husband, Tom. Someone in the courtroom shifted. I didn't look to see who. Tom didn't just believe in this company, he backed it. He signed his name on 4 separate guarantees when I couldn't qualify for financing on my own. He moved his retirement savings into our operating account during the hardest year we ever had so that our people wouldn't miss a paycheck. He sat at our kitchen table at 11 o'clock at night and ran numbers with me until the numbers made sense. Her voice cut slightly. This award has my name on it, but there is not a single square foot of anything we have ever built that Tom Reeves didn't help make possible. Not one. And I should say that more than I do. She held up the award. So this is for him too. It always has been. The video ended. The courtroom was the kind of quiet that isn't peaceful. The kind that settles on a room when everyone in it is processing the same thing at the same time and nobody knows where to look. I was staring at a fixed point on the far wall, doing what Martin had told me. Nothing. Not a nod. Not a breath that was any larger than necessary. Just steady. But I could feel Diane looking at me. For the first time all day, she was looking directly at me. I did not turn. Judge Okafor set her pen down. She looked at Philip Hartwell for a long moment. Mr. Hartwell, she said, the morning's claim was that your client built this company without meaningful contribution from her husband. She let that sentence stand on its own. What I just watched appears to be your client, under no legal compulsion, describing that contribution to 300 people at a public event less than 3 years ago. She tilted her head. How would you like to proceed? Philip Hartwell was a seasoned attorney. He had clearly been in rooms where things hadn't gone his way before, and he had the professional control to not show damage. But I had spent 30 years reading the faces of people hearing financial news they hadn't expected. And I knew what recalculation looked like around the eyes. He was recalculating. Your Honor, I'd like to request a brief recess. The judge granted 20 minutes. I walked to the hallway. Frank materialized immediately, holding a granola bar with the expression of a man who has been waiting to make a significant comment for several hours and is running out of places to put it. You don't have to say anything, I told him. I wasn't going to say anything. You were about to say something. He looked at the ceiling. I was going to say that that video was the single most effective thing I have ever witnessed in any setting, legal or otherwise, and that Philip Hartwell currently has the look of a man who stepped onto an elevator and watched the floor indicator go in the wrong direction. I took the granola bar. It was peanut butter. I had told Frank for 40 years that I preferred the plain ones. He always brought peanut butter. It was a form of affection. Martin appeared. "They want to talk," he said. I looked at him. "Already? Hartwell just handed my assistant his card. That's how it starts." He held a cup of coffee he wasn't drinking. "First offer's going to be too low." "How low?" "Low enough that you'll want to walk back in there and finish it." He looked at me steadily. "Don't." I leaned against the wall. 14 months. 14 months of depositions and discovery and phone calls with Martin, where he explained, patiently, and every time, that I needed to not do anything dramatic. That the documents would do the work if I let them. 14 months of being described in legal filings as financially reckless, professionally irrelevant, a man who had moved money without purpose or vision. "What do you think they'll offer?" I asked. Martin tilted his head. "Not enough. But Thomas, we haven't shown them everything yet." He paused. "We haven't shown them the loan origination files from First Western, or the 2014 personal tax return with the IRA distribution on it, or the fact that 3 of her current senior staff were hired on personal references I provided." He set down his coffee cup. "They don't know the size of the box yet. They've only seen what fits on a table." I exhaled. "Tell Hartwell I'll hear a number," I said. The recess ended at 3:45. Philip Hartwell walked to our table before the judge returned. He stood with his hands at his sides, not in his pockets, not crossed, at his sides. The posture of a man who has recalibrated his position and is choosing his words carefully. "Martin," he said quietly, "what does your client want?" Martin looked at me. I looked at Hartwell. "I want equitable recognition," I said. 40% ownership stake in Diane Reeves properties, valued at current market, paid out over 5 years at prime rate. My name added to the founding documents as co-financial architect, a formal correction to any public record characterizing the company as having been self-funded. Hartwell blinked once. "The magazine profile," I confirmed, "and the Chamber of Commerce biography on their website, which currently describes my wife as a solo entrepreneur." Hartwell looked at Martin. 40% is less than he'd get if we continued. "Yes," I said. "I'm aware of that." There was a brief pause. "I'll discuss it with my client." He walked back. I watched Diane receive the information. Her back was straight, her hands flat on the table, and she nodded slowly, the way people nod when they hear something they already know is true and are only now acknowledging out loud. She didn't look at me yet, but she nodded. We reconvened at 4:15. Judge Okafor reviewed both tables. "Has there been progress toward resolution?" Hartwell rose. "Your Honor, the parties have reached a preliminary agreement in principle and respectfully request 30 days to formalize terms." Martin stood. "The defense concurs, pending formal documentation of all agreed terms before this court." Judge Okafor nodded once, made a note, and then set her pen down in the deliberate way of someone who has more to say than the record requires. She looked at me directly. I stood. "Mr. Reeves," she said, "in 26 years on this bench, I have seen a great many people sit where you're sitting. People with every legitimate reason to be angry. People who spent years building something only to watch it be described as belonging entirely to someone else." She paused. "Most of them couldn't wait to show me what they had. They walked in here, ready." She looked at me carefully. "You sat here all day and said nothing. You let the record speak." She picked up her pen. "I'm going to leave it to others to decide whether that's patience or wisdom, but I'll note for the record that it is exceedingly rare." She tapped the bench once. 30 days. We're adjourned." The room began to empty the way courtrooms do at the end of something real. Slowly, with the specific quiet of people who have just witnessed more of another person's life than they expected to. Papers shuffling. Chairs scraping. The low hum of resumed conversation. Frank was behind me somewhere. and I could sense him vibrating with the effort of not saying anything, which was its own kind of tribute. I was putting on my jacket when I heard her. "Tom." I turned around. Diane was standing about 10 feet away. Hartwell was somewhere behind her, giving us the professional distance attorneys give when they've been asked for it. She had taken off the blazer she'd worn all day and was holding it over one arm. Without it, she looked like herself. Not the profile in a magazine version, not the courtroom version, just the woman who had sat across from me at a kitchen table in 2007 with color-coded spreadsheets and asked me to believe in something. She looked tired. She looked like someone who had spent 8 hours listening to the best and worst years of their own life, being read back to them in evidence numbers, and was only now feeling the weight of it. "I'm not going to ask you to understand," she said carefully, "what I did, how I let this go the way it went." She pressed her lips together. "I told myself a story about it, that I had done the work, that the money was just money, that it wasn't the same as—" She stopped. "I convinced myself it was fair. And I was just the money," I said. She flinched slightly. "Not dramatically, just enough for me to see it. That's not what you were," she said quietly. "It's not what you ever were." "I know," I said, and I meant it. Not as something generous, just as something true. We stood there for a moment that held more than either of us was going to be able to say in a courthouse hallway. "The video," she said finally. "What I said that night, I meant it." "I know you did." "Then why?" "Because meaning something and living like you, mean it, are different skills," I said. "You were always better at the first one." She looked at me for a long time. Long enough that Frank, behind me, was clearly making himself absolutely still in the way that large men make themselves still when they know the wrong movement will shatter something. "The correction to the founding documents," she said finally. "And the magazine, I'll handle it personally, not because my attorney told me to." She paused. "Because it's true." I thought about 2007. The kitchen table, the spreadsheets, the way she had looked at me and asked if I was scared, and I had looked back at her and told her I wasn't, and neither of us had known yet what that would cost either of us, or what it would make possible, or how it would end 16 years later in a courthouse hallway in October with both of us standing on the other side of something we couldn't take back. "Thank you," I said. She nodded once, the nod of a person accepting a truth they've earned the hard way, and then she turned and walked back toward Hartwell, back toward whatever came next for her, and I watched her go. And I didn't feel the way I thought I would feel. I felt mostly just tired and honest. And something close to, but not quite, okay. Frank materialized at my side with the immediacy of someone who had been waiting for exactly this moment. "You all right?" he asked. I thought about it seriously. "Ask me in a year." He nodded and handed me the other half of the granola bar. I took it. We walked out through the courthouse doors into the late October afternoon, into the dry Nevada air in the parking lot and the ordinary traffic beyond it. And I stood on the last step for a moment and looked at the sky and thought about what Judge Okafor had said. Patience or wisdom. I wasn't entirely sure which one it had been either. Maybe it didn't matter. Maybe the only thing that mattered was that for 16 years I had shown up at that kitchen table night after night and done the thing that needed doing, and the record had said so, even when no one else had. I built something. I knew that now, not in the way that gets your name in a magazine, not in the way that gets you an award on a shelf or profile with the word self-made in it, but in the way that actually counts, which is the only way that ever mattered to me. And at the end of it, in a courthouse hallway, with her blazer over her arm and the afternoon light coming through the glass doors, my wife had finally said it out loud. That was enough. It wasn't everything. But it was enough. If this story stayed with you, take 1 second to hit subscribe. We don't run ads, we don't push products, we just tell real stories about real people. And as always, thank you for being part of this community.